Congratulations on your appointment to one of our city's boards, commissions, or city council committees. Boards and commissions are essential to the successful function of city government, and your contributions will help shape the future of Denton. You will be studying and recommending policy application on a variety of issues vital to the city's future. This training is designed to assist you in your service. As a companion to your boards and commissions handbook, this video will provide a general introduction to topics and processes that directly affect members of boards, including an overview of the City of Denton governance structure, general membership information, applicability of conflict of interest in open government laws, and procedural rules governing meetings. The city attorney, city secretary, and staff liaisons are also available to assist you in your role as a board member.
The Denton City Charter was adopted in 1959 and is the basic governing authority of the city. The charter determines the form of municipal government, the composition and powers of the city council, and establishes the legal framework necessary for a city to function. The charter establishes a council-manager form of government where the city council serves as political leaders and policymakers and retains a professionally trained manager to oversee the delivery of public services. The City Council consists of a mayor and 6 council members who are elected to serve as the legislative body of the city. As a legislative body, the council members are the community decision makers. The council focuses on community goals, major projects, and long-term considerations such as community growth, land use development, capital improvement plans, capital financing, and strategic planning. The City Council appoints the city manager, city attorney, and municipal judge. All other city employees report to the city manager, who is responsible for daily operations of the city. The city manager is appointed by the council to serve the community through the professional administration of local government projects and programs. The city manager prepares the budget for the council's consideration, recruits, hires, and supervises the local government staff, and serves as the council's chief advisor by bringing forth objective information regarding policy matters. The manager makes policy recommendations to the council, which the council may adopt, modify, or reject. The City Council also appoints the city attorney. The city attorney's office serves as the legal branch of the city, representing the city's legal interests and rights, providing legal advice, and prosecuting criminal complaints. Among other things, the city attorney's office drafts and reviews the city's legal documents and issues legal opinions. The city secretary administers the city's board and commission program. The city secretary is also responsible for conducting city elections, preparing and posting city council meeting agendas and minutes, and maintaining the official records of the city. The city manager assigns a staff member to work with each board or commission. The staff liaison's role is to prepare meeting agendas, staff reports, and supporting information to the commission prior to meetings, ensure compliance with the Texas Open Meetings Act, prepare board recommendations to the City Council, and make presentations to the City Council on behalf of the board, respond to board members' requests for information related to the business of the board. Board members do not have authority over the work program of city staff. Rather, the liaison acts as an information resource and provides technical assistance. A board or commission may request staff's assistance on various projects. However, the city manager must approve all requests which create a substantial amount of work for staff. You, as an interested and informed citizen, are essential to effective local government. Because your viewpoint is so valuable to the city council members, they take your appointment, attendance, and involvement on a board very seriously and ask that you do also. The council is aware that board members have careers, families, and other responsibilities that demand their time. However, because of the importance of citizen boards, the City Council asks that each new board member make every effort to attend all meetings of the board and notify the staff liaison of their board in advance if they are unable to attend a board meeting. The unexcused absence of any board member from more than 3 regularly called and scheduled meetings in any one year, or the lack of attendance at 50% of the number of regular meetings in a year, will be considered cause for removal. An excused absence includes illness, death of a family member, jury duty, military service, testifying before the legislature, attending a seminar relative to the member's duties, or absence necessary for business or employment, among others. The staff liaison will provide a staff member at the meeting of each board to take minutes of each meeting in a form consistent with City Council meeting minutes to reflect an accurate record of business transacted at the meeting. Minutes of the meeting will be submitted for approval by the members present at the next meeting with revisions, corrections, or amendments being made at that time. The chair and vice chair will be elected annually by voting board members. If, for any reason, the chair or vice chair vacates their seat, a special election should be held to fill the unexpired term. A temporary chair may be selected by the board pursuant to Robert's Rules of Order. The staff liaison shall serve as the official secretary to the board or commission to ensure records are maintained in accordance with requirements of the city secretary's office. The City Council has adopted an ethics policy that applies to all council members and appointed city officials, including board and commission members. You can access the policy in your handbook. Note the ethics policy lists some state penal laws that may be applicable to members. Please consult the city attorney with any questions about the policy. There may be times when your board or commission would like to suggest policy recommendations or seek clarification of policy statements from the City Council that fall within the scope or purpose of the board. A majority of the board or commission may request that staff propose questions or policy statements for response or consideration from the City Council. Boards and commissions may also provide an annual or more periodic report to the City Council as appropriate, outlining their activities, accomplishments, projects, and initiatives. The Denton City Charter requires all board members to comply with the state conflict of interest laws. State law requires a board member with substantial interest in a business entity or real property to file an affidavit with the staff liaison and abstain prior to a vote or decision on any matter involving the business entity or real property, if the action on the matter will have a special economic effect on the business entity distinguishable from the effect on the public, or if it is foreseeable that the action on the matter will have a special economic effect on the value of the real property, distinguishable from its effect on the public. For example, the Attorney General has opined that a special economic effect on the value of real property distinguishable from the effect on the public exists when a P&Z board member has an interest in real property located within 200 feet of property being rezoned. However, the AG made it clear that these evaluations are highly fact-intensive. Ask yourself the question, will this action before my board affect the value of my real property in a manner that is different from public at large? You have a substantial interest in a business entity, nonprofit or government entity is not a business entity, if you own 10% or more of the voting shares of the business entity, or own either 10% or more than $15,000 or more of its fair market value, or you receive funds from the business entity exceeding 10% of your gross income for the previous year. You have a substantial interest in real property if the interest is an equitable or legal ownership with a fair market value of $2,500 or more. You have a substantial interest if your close relative, within the first degree of consanguinity and affinity, has a substantial interest. A violation of Chapter 171 is a Class A misdemeanor, although penal provisions are not applicable to advisory board members. If you think you have a Chapter 171 conflict, contact the staff liaison prior to the meeting to make arrangements for the signing of the required affidavit. If you have any regarding potential conflicts of interest, please contact the city attorney through your staff liaison. There are times you will have a perceived conflict of interest even though it is not a conflict that is prohibited by law. In those cases, you should make a judgment call as to whether you should abstain from the matter. The city's ethics policy states, "I will act with integrity and moral courage. I will be absolutely truthful. I will make impartial decisions that are free of bribes, unlawful gifts, narrow political interests, and other personal interests that might impair my independence of judgment. I will always decide what is best for the whole city." If you think the perceived conflict affects your ability of independent judgment, or there is a strong appearance that you lack the ability to divorce yourself from the perceived conflict in making a decision, you should carefully consider whether abstention is appropriate. Often, these are difficult judgment calls for which there are no absolute right answers. In making your decision, you should weigh the harm of participating against your general duty to serve on the board. You have a duty to participate and vote on all matters that come before the board, unless you have a conflict or you lack information to decide the issue. Chapter 176 of the Texas Local Government Code requires you to file a Conflicts Disclosure Statement, CIS, with the City Secretary if you or your family member, A, has an employment or business relationship with a city contractor or vendor that results in taxable income, or B, received or accepted one or more gifts from a city contractor or vendor, excluding gifts of food, lodging, transportation, or entertainment accepted as a guest, with an aggregate value of $250 in the preceding 12 months. You are required to file the form within 7 days after you become aware of the relationship with the city. The CIS is signed under penalty of perjury and is a Class C misdemeanor to fail to timely file the form. However, it is a defense to prosecution if you file the CIS not later than the 7th day after you receive notice of violation. Therefore, you have 2 chances to comply. By City Council rule, all boards must comply with the Texas Open Meetings Act. The Act generally provides that meetings of a board shall be public, although there are a few exceptions whereby a decision-making body may deliberate in a closed meeting. The most common exceptions include consultation with attorney, deliberations about real property, deliberations about gifts and donations, personnel matters, deliberation about security devices, competitive matters of certain public power utilities, and deliberation about economic development negotiations. There are criminal penalties for holding an unauthorized closed meeting for boards with decision-making authority. Written notice must be given of dates, times, and locations of all meetings. Minutes of each meeting must be taken, and a record of votes and decisions kept as public record. It is important that when more than 2 members are in any given place where city business is being discussed, the meeting should be posted as a precautionary measure to avoid the accusation of attempting or conspiring to conduct city business in private. It is also very important that the board limit discussion during meetings to only those items listed on the posted agenda. Conversation or action on items not posted on the agenda would also be considered a violation of the Act. The Open Meetings Act does not apply to purely social gatherings, conventions, or workshops, such as Texas Municipal League events. Any specific question or issues should be referred to the City Attorney's Office through the staff liaison. The City Council has formally adopted rules of procedure that govern the proceeding of City Council, Board, and Commission meetings, except where those rules are silent. In that case, the most recent edition of Robert's Rules of Order shall govern. The rules of procedure also address the Code of Conduct and participation guidelines for citizens, staff, and board members. A copy of the rules of procedure is included in the appendix section of your handbook. The function of the chairperson is to provide leadership to the group in the following ways. 1. To maintain order by enforcing the established rules, and 2. To ensure the meeting proceeds smoothly and follows the agenda. If the group is indecisive, the chairperson should exercise leadership and make suggestions. When debate is concluded, the chairperson should summarize the major points made. In general, the chairperson should maintain order and try to bring the group to a conclusion on matters before it. It is important that the chairperson understands the parliamentary procedures of the board and is willing to use them to facilitate the business of the board. Here are a few obvious points that should be followed, but are often forgotten. 1. The chairperson should recognize the person or persons who wish to speak, and only they should be allowed to speak. Others should hold their comments until they have the floor. 2. The board should discuss only one point at a time and should only discuss those items that are listed on the public agenda for discussion. If a board member would like to discuss an item not on the agenda, he or she may request that the item be placed on a future agenda for discussion. The discussion of an item that is not listed on the agenda may be a violation of the Open Meetings Act. 3. Before discussion of an issue by board members, a motion should be made and seconded. The making of a motion normally occurs following a presentation or description of the issue by a staff member or chairperson. After the motion is made and seconded, debate can be conducted. Example of the proper form of a motion is, Mr. Madam Chairperson, I move the following. 4. If the meeting is a public hearing, the board should hear the public without making comments until questions are allowed by the chairperson. Board members may listen to citizens speak and may ask questions of citizens for clarification on the issue. Board members may not engage citizens in a discussion of the topic because to do so could potentially be a violation of the Open Meetings Act. These are important procedural rules that allow the public to clearly follow the deliberation of the board and provide for the most accurate recording of meeting minutes. The rules of procedure accommodate public comment on agenda items and public hearings. Members of the public may sign up to speak on regular agenda items by signing up with the recording secretary. Members of the public are also able to speak on items posted as a public hearing. Speakers generally have 4 minutes to address the board regarding the specific item. Further information regarding public participation in meetings may be found in the Rules of Procedure in the appendix section of your handbook.
Again, congratulations on your appointment, and thank you so much for your interest in serving your community. Your efforts will make Denton a better place to live and work.